action, entertain a motion to refer first speaker's request, House Bill 1434, to Committee on Education. Move to second to do that. All those in favor say aye. Aye. All opposed? Okay, that is done. Delegate Bulova has requested to strike House Bill 2307. Our favorite motion.
So moved.
Move to second to let Bulova kill his own bill. All those in favor say aye.
Aye.
All opposed? Okay, that happens. Now we identify, say, Delegate Habib. Go through the civil uncontested.
Thank you, Mr. Chairman. I'll explain the bills and note which ones have amendments and substitutes, and if it be appropriate, move the subs and line amendments at the end. Everything should be in the stack in front of everybody. If we have any new amendments, those are in the contested block, so everybody has everything. The first bill is House Bill 1590 from Delegate Campbell. This clarifies the fireman's rule and carves out gross negligence claims. House Bill 1609 from Delegate Leftwich picks up a drafting error we had in last year's nurse practitioner's expert witness bill. House Bill 1689 is my bill that sets the parameters for charging fees for medical records. This has been negotiated between medical records providers, Medical Society of Virginia, and the trial lawyers. 1699 is a pilot program brought by Delegate Marshall regarding recordation of deeds subject to liens in the city of Danville. This has been reviewed by the Housing Commission. House Bill 1737 is a Boyd Graves bill supported by the Family Law Coalition, extending personal jurisdiction for civilian employees and foreign service officers. It just picks up one group of foreign service officers, or civil employees that are left out of the existing code. House Bill 1746 from Delegate Rush deals with possession and administration of epinephrine and brings higher ed in line with K-12. House Bill 1748 exempts additional employees of clinics from liability, the administrators similar to the medical providers. House Bill 1811 from Delegate Lupasi is an agreed bill from the Office of Executive Secretary, the AG's Office, Virginia Poverty Law Center, and others regarding unlawful detainer actions and when you can take possession and money judgment. It's a long bill that does lots of other things. HB 1832 from Delegate Kilgore clarifies the statute of limitations for negotiable and non-negotiable certificates of deposits the same. HB 2024 requires that the notice required in a quick take proceeding be done 15 days prior to filing. There's currently no time period, just a requirement to file. HB 2035 from Delegate Miller shifts the $5 fee from, instead of being $5 to file electronically, it's $5 to file on paper. This will help incentivize more people to use the electronic filing. HB 2276 from Delegate Wilt puts a procedure in place for amendments to death certificates, and the substitute clarified who can file it, where they can file it, and who should be given notice. HB 2289 from Delegate Leftwich is a Boyd Graves bill supported by the Family Law Coalition regarding life insurance proceeds upon divorce or dissolution of marriage. And HB 2328 from Delegate Campbell's Virginia Poverty Law Center bill, which adds the same factors the court applies to determination of indigency and appointment of counsel to determining a person's ability to pay fees and costs in civil action. I believe that's all the bills, Mr. Chairman. I would move all the substitutes and line amendments.
Second.
Moved and seconded to adopt all the substitutes and line amendments. All those in favor say aye. Aye. All opposed? Okay, so all the substitutes and amendments are added. Is there anybody who wants to take any of these out of the block? Okay, hearing none. Then the vote would be to report these as amended. So move forward. This is the criminal subcommittee report, uncontested. Mr. Chair, we have a number of matters on the uncontested docket. House Bill 1411, Delegate Elbow,
dealing with withdrawal as counsel. House Bill 1525, Delegate Albo, involving revocation or suspension of driver's license with laws of other jurisdictions. House Bill 1622, Delegate Collins, involving CDLs and DUIs. House Bill 1799, Dr. O'Bannon, dealing with cannabidiol, or pharmacy. House Bill 1851, Delegate Gilbert, involving assault and battery against a family or household member and deferred disposition. House Bill 1855, my bill involving court-ordered restitution. House Bill 1951, Delegate Peace, involving training for CJSB and its committee. House Bill 2051, Delegate Adams, involving marijuana possession and driver's licenses. House Bill 2073, Delegate Watts, involving the Virginia Consumer Protection Act. House Bill 2084, Delegate Herring, involving search warrants. House Bill 2231, Delegate Miller, involving the ignition interlock system. House Bill 2240, Delegate Miller, involving crime victims non-disclosure. House Bill 2287, Delegate Collins, involving confidentiality of records at DJJ. House Bill 2338, my bill, involving restitution and prioritization of payments. House Bill 2386, Delegate Posse, involving court-ordered fines and deferred installment payment agreements. House Bill 2467, my bill, involving driving on a suspended or revoked license and the period of suspension. Mr. Chair, all of those were unanimous to report, and I so move.
Second.
I'm sorry, I apologize. Mr. Chair, okay, I understand it's been withdrawn. I would like to adopt all of the substitutes and amendments, and almost all of them had a substitute or an amendment.
Okay, so the motion is to adopt substitutes amendments has been seconded. All those in favor say aye.
Aye.
All opposed?
Mr. Chair, I would now move to report all of these unanimously reported substitutes and originals with amendments.
Okay, does anybody want to remove anything from the block? Okay, hearing none, the vote would be as moved by Delegate Bell and is seconded by someone.
Second.
Okay, to report these as a block. Okay, Toscano and Adams. Okay, close the roll. Those report.
Mr. Chair, let's take, we have a report refer that were unanimous.
So report refer.
Yes, sir.
Okay.
Mr. Chair, we had two bills that were unanimously reported and if accepted would have to be reported or referred up to appropriations. House Bill 1856, which is my bill involving restitution. House Bill 2127, Delegate Levine, involving purchase. I would ask that we accept all amendments and substitutes for those two bills.
Okay, moved and seconded to accept all the amendments and substitutes. All those in favor say aye.
Aye.
All opposed? Those are adopted.
Mr. Chair, I would now move that we report and refer both of those bills up to appropriations.
Okay. If anybody wants to remove those from the block?
All right, let's take the Levine one out of the block.
Okay.
Line with the,
All right, so the Levine bill, which is 2127, is out.
We'll do that on the contested docket. As well. Mr. Chair, we'll do that as part of the contested bills.
All right, block of one. Who wants to report this? I need to vote on the electronic voting board. Okay, all those who want to refer that bill, indicate your vote, electronic voting board. Okay, it's on here. Okay, close the roll, report is 20 to 0.
Mr. Chair, that's the uncontested
Okay,
docket.
so let's go ahead and do Elliot Helsel. You got one? Oh, you're here for the subcommittee? Your bullet, you got one? You got one. 1765. Delegate Bell, why don't you tell us what the report of the meeting? Okay, so I'm informed this bill already came out of sub, and we're just basically bringing it up right now, and this is a new substitute. Dave?
It is a new subject.
Okay, so motion on the substitute, is there a second?
Second.
Give a second, not the substitute, all those in favor say aye.
Aye.
All opposed? Okay, tell us what your bill does, and remind us.
Thank you, Mr. Chairman, and if I go on too long, please tell me to hurry up.
Okay, you're too long.
Let me give just a couple really quick points about the background, and I'll tell you exactly what this does. So this was a constituent of mine whose daughter was being subjected to bodily assaults by an individual. The daughter turned around, told her father, who confronted the individual. That individual actually then assaulted my constituent with a knife. The individual was arrested. He was found guilty in General District Court, sentenced to 2 months in confinement. As is his right, he appealed to the circuit court, in which case the court was held de novo. However, unfortunately, the individual then did not show up in court, never contacted the court again, still free today. And so I think from the constituent's perspective and my perspective, that sends an awful message to the victims. You can have somebody who's done something wrong, does something wrong again by not showing up in court, and then is out there with just an arrest warrant. The issues that we discussed in subcommittee is that while a circuit court may try a person in absentia, they can't sentence the person in absentia. And so for the rest of the world, it just shows that the case is pending, which is probably why you have very few cases of somebody doing that or doing an absentia. And then also the other one is that certainly you can wait until a person is caught, but the longer that you're doing this, the more difficult it is to try the case. In addition to assault and battery, it could have well just been DUI, could have been stalking, a number of other offenses. I think the original concern in subcommittee was about the constitutionality about sentencing in abstention, which I guess we cannot do. Our chairman Albo is actually the one who came up with a beautiful solution to the issue by really just saying that we would change section 16.1133 to state that failure to show up in accordance with the conditions.
They're complimenting you on the brown nosing.
Oh, thank you. So anyways, basically, if you don't show up to the court, that constitutes a withdrawal of an appeal. And so that's the language that you have on line 23 and 24. The other point is we don't want somebody accidentally not showing up. So they've overslept, they forgot, and so we had a safeguard in there that as long as it was not willful, the judge can reopen the case within 60 days and take care of it that way. The only constitutional issue that remained was notification. And so Hunter versus Commonwealth, an individual has to be notified before they're allowed to waive their rights. And so this is the language on 24 and 26, which essentially says that you have to be notified of the fact that if you don't show up, that you've waived your right to the appeal. So again, appreciate the subcommittee's work on this. Commonwealth Attorneys Association is in support. They really did a great job. My understanding is that the Supreme Court has also helped to review this from a technical standpoint to make sure that the bill works. But
Okay, does any members of the committee have any questions for Delegate?
I got a question.
Okay, use your request to speak button.
I already did.
Well, I got Collins, it said he is ha ha ha.
Are you gaveling me down fast?
Okay, Delegate Collins.
Thank you, Mr. Chairman. I know I voted against this in subcommittee. I think one of the concerns, most of my concerns have been alleviated, but I did have a question. If I appear for my client as his attorney, say on a reckless driving ticket, and I note an appeal to circuit court, and then I don't appear, because I told my client I'll appear on her behalf, do we have any idea what effect that might have? Well, I get that.
You're getting good bargaining.
I think that, I can't say that, in the course that I practice, you need to have a notarized document giving authority to your attorney to enter a plea on your behalf.
No.
Yeah? Doesn't have for you guys?
No.
So let's, Steve, you may answer this question, you think?
In that, Mr. Chairman, in that case, I believe we'd be looking at the 60-day reopening. You'd have to just, it's gonna cost you more money, it's gonna cost your client. If you charge them, obviously, you probably wouldn't, but that would be covered under the 60-day reopening.
Mr. Chairman, may I ask a question related to that?
Hold on for a second, is Collins done?
Related to that.
Okay, Delegate Posse.
Okay, just to piggyback on that. So what if it's gone, Mr. Attorney, what if it's gone 63 days? Then what? Habeas corpus?
Probably malpractice. In Mr. Collins'
Okay, that-
example.
Mr. Chair? Okay, here, and all due respect to the gentleman, he's not a lawyer, but a lot of us are. The concern that I have is there are many, many times in our law when criminal defendants don't show up for things, okay? And when they don't show up, they issue a capias, and then the man goes and hunts them down and brings them into court. That's why we have courts, to litigate these, to bring them in. That's why we have police officers to go lock them up. But not just find people guilty. You're taking away an appellate right, and you're doing it, and it doesn't make sense to me. Potential jail time, criminal conviction that you have for life. If you want to do away with the right to appeal de novo, then just do away with the right to appeal de novo. In other words, that's it. But that's what this does, it's gutting that.
Well,
Mr.
your
Chair.
analysis is correct.
Mr. Chair.
Yes, Delegate Bell, you just request to speak, but. Delegate Bell.
Mr. Chair, no, I mean, sorry, I say to the gentleman from, where I go? Richmond City. I say to the loud gentleman to my left. There's no good answer when the defendant has his trial, is found guilty, either pursuant to a plea or the judge, and district court does it. He then properly starts the appeal, but then doesn't finish it. And the question is, what happens at that moment? As time goes by, he has successfully disabled the ability of the complainant to get a trial. I mean, witnesses move, witnesses die, people move on, and the capias remedy is not a very good one. Now, what we're doing is we're saying you have the right to an appeal, absolutely, but you actually have to show up for the appeal, and if you skip, you can't thereby avoid the conviction forever. And that's what this would do. So I think it rebalances that a little bit, but I think it's a good rebalance.
All right, anybody else want to speak for or against the bill? Anybody in the audience want to speak for or against the bill? Not in the audience, yes, sir.
Mr. Chairman, the Supreme Court pointed out that on line 25, the notice would actually be given to the person when he notices his appeal, not at the time of conviction, so we need to make that change.
Notified in writing at the time of his appeal.
At the time he notices his appeal.
Okay, so motion is to strike at the time of his conviction and insert at the time of his appeal. Kilgore makes the motion.
Second.
Moves and seconded. All those in favor of that, say aye. Aye. All opposed? That is adopted. Delegate Klein.
Speak to the, we did have a debate, along the lines of, what Delegate Lupasi was talking about, but one of the things we realized is that the Commonwealth's attorneys drove home was that, this is not just a theoretical debate, it's not a philosophical debate, this is a real problem. It's a real problem that's happening and it's increasing. And more victims, are not seeing justice happen because these cases are being lost 2 years down the road. And so, I agree in part with the gentleman's comments, but I'd like some suggestions on how we can solve the problem that's growing increasingly across the Commonwealth. So that's why I'm going to support it.
Okay, Delegate Lupasi.
All right, Mr. Chairman, here's the number of issues as I see it. Oftentimes people go to general district court, they're not represented. There's no means of discovery, there's no meaningful means of discovery in the Commonwealth of Virginia. They might not be represented. They go to court, they get quote unquote railroaded, convicted, appeal, note their appeal, and you're putting on them the idea that when they sign a sheet of paper, because oftentimes they're hurried through the court system, they go through the door-marked clerk, he says, well, I want to note my appeal. They say, fine, sign these sheet of papers, here's your next court date, and you're out the door, okay? He doesn't have any idea what he just signed, just like Albo did when Albo bought the tickets, okay? He didn't have any idea what he was signing, he didn't have any idea, because he didn't read the paper, okay? It's the same thing that we do as citizens every single day of our lives. We sign away our lives, we sign the sheet of paper, and we go on out the door, okay? But there's a big difference, because after 60 days, and a lot of people aren't as sophisticated as the gentleman down here that talks fast and is smart, okay? They're not as sophisticated as you, and they're not as smart as you. They don't read their papers, and they don't understand any of this. A lot of them haven't even been in court for the first time in their lives. Now all of a sudden, and I'm not trying to, I understand it's a problem, but I think it'd be a worse problem to stick criminal convictions on people like this without an opportunity for counsel, without an opportunity for a jury trial, without an opportunity for meaningful discovery in the Commonwealth of Virginia. Okay, there's a lot of problems. So you're making it worse, in my opinion. And so I'm going to vehemently vote against this bill because I think it's patently unfair and it's going to lead to massive injustice, in my opinion.
Delegate sophisticated.
Mr. Chair, I agree that he may not have read the form properly. The issue is, what do we do when he doesn't show up? He still doesn't show up. Doesn't show up a week later, doesn't come by the court 10 days later, 15 days later, 20 days later, finally says, my gosh, did I miss my court date? 30 days later, 40 days later, 50 days later. At some point, we have to say he is not making any effort to pursue this appeal. He's already lost the case in lower court. So I'm not saying this is a perfect solution, but in a set of bad choices, this is the best choice available to us. So, Mr. Chair, I'm happy to continue the dialogue. I move your bill.
So the way we work with the audience is if someone wants to speak, you just launch this an official system. You line up by these two pillars and you wave your hands. Okay? Okay.
Mr. Chair, Nancy Parra, Commonwealth Attorney for the City of Chesapeake on behalf of the Commonwealth Attorneys Association. And as the patron said, VACA supports this bill and has worked on this. And we would really ask you to pass this. It would be a great assistance to our victims in Virginia.
Okay, thank you. All right. Then the motion by the subcommittee was to report as amended. Is there a second? Second. Okay, moved and seconded to report. All those wanting to report? And the substitute. We already adopted this, we amended this. Okay, so we're reporting the substitute as amended. All those who want to vote indicate your vote on electronic voting board. Reports 12 to 9.
None of you guys would vote for that.
I'm sorry.
One of you would have voted for that if it was our bill.
For a lot of your stuff.
Maybe Mullen, I'm sorry.
Are there any other delegates here who have bills before the full committee?
Thank you, Mr. Chair.
Okay, let's just start going down the document. because I don't want the mental health people to have to leave here at 7 p.m. So let's go ahead and Delegate Habib, let's start doing some of your
Yes, sir.
simple contested.
Yeah, and most of these actually are only contested because of either one vote or an amendment. I think we can move fairly quickly through them.
I would say, Delegate Campbell, you wanted to move your 1586 to next week.
No, he would, it's 2128 that we're going to take by with the Levine bill.
Oh, it's Levine's 2128.
Yes, sir.
Okay, so that bill, for anybody who's here, delegates, some witnesses who wanted to testify are sick today, so we're going to send it off to our next meeting. So if you're here for House Bill 2128, you probably want to go because we're not going to hear it today.
I move that by for the day.
Okay, bye for the day. Is there a second? Move the second, bye for the day. All those in favor say aye.
Aye.
All opposed, that's bye for the day. Delegate Habib.
All right, Mr. Chairman, HB 1514 from Delegate Fowler simply expands the list of providers that can give DMV notice of disability and by adding a list of them, and also makes it clear that they are exempt from HIPAA liability. The vote was 8-1, and I would move that we report the bill. Oh, excuse me, I would move that we adopt the substitute first.
Move the substitute. Is there a second? Second. Move the second, adopt the substitute. All those in favor say aye.
Aye.
Aye. All opposed, substitute's adopted.
Report the substitute.
Mr. Chair, for the substitute, Delegate Bell.
I don't want to slow things down, but somebody didn't like it enough, if they feel strongly.
He likes it now.
That's fine. I would ask for these all, that if somebody feels strongly, to tell us.
Okay, all right, and the motion by Delegate Habib is to report the substitute. Is there a second? Second. Move the second to report the substitute. All those who want to go to this bill indicate your vote on the EVP. Okay, close the roll, reports 21-0. Delegate Habib.
Mr. Chairman, House Bill 1524 is Chairman Lingenfelter's bill. A few years ago, apparently for SCOPs, we changed the rules. Instead of requiring a bond, they had to get insurance. When DCJS entered their regulations, they picked the type of insurance that the SCOPs can't actually get, apparently. So there's been a whole bunch of meetings. That's why this bill's on the contested docket. There's a substitute before you that requires the SCOPs to have injury liability insurance, property damage liability insurance, and miscellaneous casualty insurance. I don't know why it's easier to get 3 forms than 1 form, but they say they can get that. It's what the SCOPs want. The recommendations, we report that as unanimous vote. I would move the substitute and then move the report.
Okay, move the substitute second. All those in favor of the substitute say aye. Aye. All opposed, substitute's adopted. Now, why was it contested?
Because we knew that substitute was coming.
Oh, just you wanted to see it first?
Yes.
Okay. Any members of the audience want to speak for or against the bill?
Good afternoon, Mr. Chairman, committee. My name is Tom Fitzpatrick from the Department of Criminal Justice Services. I've been asked to inform you that the administration opposes this bill. I understand that you have the committee structure with the civil court to hear these issues. I apologize that our informing you is
Okay.
just this morning.
So,
And I informed
so
that,
slow down.
sorry.
So you gotta remember that half of us have nothing idea of this because we weren't in the subcommittee. So
Understood.
explain to me why you guys don't like it.
So the board this summer adopted the requirement for the professional law enforcement liability. And that requirement was based on the nature of what SCOPs do and the abilities of what they can do. I understand there was a meeting on Wednesday to discuss the nature of that insurance. I apologize that we were not able to make it there for that meeting. I didn't call the delegate's office this morning when we found out that the administration's position was to oppose this bill. We are happy to take a look at this issue. I understand that there are 3 components that the committee, or that the delegate had worked on in the substitute, but the board recommendation was to have this insurance called professional law enforcement liability, which is not enumerated in the substitute amendment that was made here today.
Okay, so hold on. So why exactly don't you guys like it?
Because of the nature of the insurance and the nature of what the SCOPs do, they have arrest powers, they carry firearms, they wear the term police on their shirts. So what they're essentially doing are law enforcement responsibilities. There are private citizens that are SCOPs, and we feel they should have that insurance that's called
Okay, so
professional law
you think
enforcement
that the
liability.
insurance that's in this bill is not adequate to cover the type of work that an SCOP does?
That's correct.
Got it. Okay, Delegate Habib.
Yeah, so the issue is, we heard testimony from DCJS that there were over 5,000 licensed SCOPs. We heard testimony from DCJS that 26 of them have been able to comply with the insurance requirement put forth. As a result of that, a meeting was convened to which DCJS agreed to attend and then chose not to attend when Chairman Lingenfelter worked his bill out with all the other stakeholders. They had an opportunity to be heard at the committee. They passed on their opportunity to participate in the meeting. The bill is now before us with what the insurance industry and the SCOP thinks are the appropriate 3 types of insurance to cover them. DCJS is upset because we've picked different insurance than what they are mandating through their regulations, which is of course our prerogative to do. And so again, I think we heard all of this. I think they had an opportunity to be heard both in the subcommittee and in the meeting. They clearly have picked the type of insurance that interferes with SCOP's ability to do business, and I would move the report.
So is it the current situation that you have 5,000 SCOPs and only 26 are insured? So at least this will insure the remainder. May not be the perfect insurance, but it'll be much better than the current situation.
This would allow the SCOPs to obtain insurance which lets them comply with the law, which they can't currently do because of the regulations issued by DCJS.
Okay, great. And then you guys know you always have the last word.
I understand and I apologize that we were not able to.
That's all right. Listen, you're doing your job, so we appreciate the situation you're in. Okay. So on the motion then, we need to report any substitute. All those want to vote this bill, indicate your vote in electronic voting board. Okay, close the roll. Report is 18-3. All right, Delegate Habib.
Mr. Chairman, the next bill is out of Campbell's bill, which we had a substitute for, and I believe he has a line amendment today, so I would move the substitute and then ask Britt to report the line amendment.
Mr. Chairman, we have 4 line amendments to the substitute that's in front of you.
Is
The
there a
first,
substitute here?
there is, yes.
The substitute's in front of you that we adopted.
It should be in a contested civil
Can
package.
I move the substitute and then have her report the line amendments?
All right, so first is the motion to adopt the substitute. All those in favor of the substitute say aye. Aye. All opposed, substitute's adopted. Delegate Habib.
And then I would ask Britt to report the line amendments.
On page 3 of the substitute on line 68 through 69, after order, strike addressing the exchange of the children subject to such order and insert prohibiting a party from picking the child up from school. Second.
Mr. Chairman, there's other line amendments.
The second of the 4 amendments is on page 3 of the substitute, line 73, after order, insert and prohibits a party from picking the child up from school. Page 6, lines 134 through 135, after order, strike addressing the exchange of the children subject to such order, insert prohibiting a party from picking the child up from school. And the last one is on page 6, line 140, after custody order, insert and prohibits a party from picking the child up from school.
Mr. Chairman, I move those line amendments.
Okay. Second. All those in favor of line amendments say aye.
Aye.
All opposed? Okay. Delegate Campbell, can you go ahead and explain this bill for people who don't understand what this is, who is named Aldo?
I'd be happy to, Mr. Chairman, following the Albanian methodology of presentment. I'll recite a hypothetical factual situation to identify the problem. Mom and Dad Albo and little Johnny Albo are living in domestic tranquility. And Mom and Dad Albo enrolled little Johnny in Acme School. And for 1 year, they live in bliss. And then at the end of the year, Mom Albo no longer likes Dad Albo because he spends too much time drinking and playing in bands and going to Iron Maiden concerts instead of going to family vacations.
Getting so far.
And so they end up in court in a custody battle. And the court sees fit to award Mom Albo full custody.
Smart.
So Dad Albo, being the smart lawyer that he is, runs to the school one day where he knows he's still on the pickup list and the school administrators have no knowledge of the change of custody, and secretes little Johnny off to a remote location, thus causing chaos in the school and in the family and in little Johnny's life. So the purpose of this bill was to try to communicate changes in custody that might affect the child's school and well-being to the school system, brought to you by superintendents. So So the law currently is, again, following the Albanian methodology of presentment, is that the courts are not required in any way to transmit those orders to the school. And most judges, I'll say most, will advise the parties, especially if they're pro se, of the need to do so. But on occasion, they don't. And if you have someone that's not sophisticated, they don't understand the need to do that. And so what we're trying to do here basically is change the law to provide that the court would transmit the order to the school system, so they would be on today. So.
All right, any members of the committee have any questions?
Mr. Chair.
Delegate Bell.
So, children custody, no, this is a problem. Is this, do we do this for other things? Daycare, private school?
And it may well be a problem in those venues as well, but it's just been brought to my attention by the school administrator.
And the school, again, I see this happen when I pick up my daughter, but I'm not, it looks like they have a list of who can pick them up. Is that sort of the?
That's correct.
Okay. I just don't want them to have to be the judges. All right.
Delegate Morris.
Question for the patron.
Yes, sir.
I'm not disputing the need to have the school to have this order, but I don't see a financial, fiscal impact. I mean, the taxing weight upon the clerk's office to get these documents to the school, has that been considered, and is there a measurable amount that would be put on the court, on the clerk's office?
I think the fiscal impact's minimal. Requires transmission of the order to the school, and that would only be upon request really by the parties under the bill as we're trying to pass. The way the bill's drafted currently, the court would order the parties to do so. And if the parties wanted to enlist the court's assistance in that, they could. So.
Delegate McGee.
Mr. Chairman, just speaking to the bill, just want to make 3 points. A couple ways the bill has changed since it was filed. When it was first filed, it required the court to do all of this. Now the parties can be ordered to do it, with the only exception being when the guardian ad litem requests that the court can do it itself. For the obvious situation, the guardian ad litem doesn't trust the parents to do it. So that's one thing we've improved for the court system. Second issue, I believe the school superintendents, some of us were concerned that once they get this notice, it could increase their liability exposure if they fail to follow it. The school superintendents actually supported the bill and said they would rather have this information in their hands than not having information in their hands. And then we've also narrowed the orders it applies to. It was sort of all custody orders. It's been limited to only those orders that have a prohibition against a parent picking up a child now. So it's actually probably a fairly small subset of all the custody visitation orders that would be entered. So it passed in its former form, 7-1. It has actually been narrowed since then with these line amendments to clarify the orders. So at the appropriate time, I will move that we report the bill as amended, although I think there's some folks who would like to speak to it.
Okay, members of the audience want to speak for or against? Come on up.
Thank you. Sandy Harrison, Office of the Executive Secretary, Supreme Court of Virginia. I agree with Delegate Habib's comments about the narrowed scope of the bill since it was first introduced, and so there is a commensurate reduction in the workload on the clerk's offices to transmit the order. And I appreciate Delegate Campbell working with us on this. We had requested, and he declined, just to clarify one point, it's not just upon request of the guardian ad litem, but upon request of the parties that the clerk's office would have to transmit the order to the school. And so our request had been an amendment that would have required the parent to demonstrate good cause that why they couldn't get the order to the school, and also to require the parent, if they demonstrate that good cause, to provide the school's contact information to the clerk in order to facilitate the clerk getting that done. It's unlike the circumstances where the clerks are directed to send a protective order, and we have an interface with VSIN. This would be every public school, every private school, potentially daycares, depending on how it's read. So that was our request to narrow. Thank you, and I'll be glad to answer any questions.
All right.
Ditto.
So you want it to be narrowed, you want the bill to say, you have to show good cause.
Mr. Chairman, I think that would be of assistance. The concern is for the clerks is what school, what contact information, oftentimes that's not reflected by the parties in the court order, that sort of stuff. And again, the default language in lines 146 to 148 right now basically says any party or the guardian ad litem. So it would be easy for the party to just say, I don't want to deal with the school, just have it sent to the school. So again, that's the good cause shown sort of covers that situation.
It took me a while to figure out, I recognize your face and now I remember. Go ahead.
Good afternoon.
Good to see you.
I'm Kim Ramsey, and I'm here on behalf of the Virginia Family Law Coalition. We had the same concerns that have just been voiced, but another concern about this is possibly causing more litigation in the sense that it's saying that the party has to submit these within 3 days of the court providing the order to them. There's no mechanism in here for how it will be proven when they have received the order. It could cause show causes by the other parent or by, saying you didn't do it within that time. There are problems with that. There are also some confidentiality problems because where are these orders going to go when they get to these schools? Are they going to just be stuck in a file? Are they going to be in the school's office? So the information that is protected when families are in court in juvenile systems, where they're closed courts and no one is allowed to come in and see what's going on with that, is now going to be in an office somewhere, maybe under lock and key, maybe not, maybe lying on someone's desk. That's a bit of an issue in and of itself. And then the very last line of the section says, nothing in the section shall be construed to require any school staff to interpret or enforce the terms of the custody or visitation order. So does it really have any teeth? And doesn't what the school system does now with having lists of people of who can pick up this child do the same thing? And I don't think it's a very practical problem that an order is entered and the school doesn't know that someone can't pick up the child, because in that instance the other parent is going to get that order there right away. They're going to be the first ones to do that, rather than counting on the clerks to send that in. And so I just don't practically think that's an issue. So definitely the amendments that have been made are big improvements, but it's still something that the Family Law Coalition opposes at this point.
Mr. Chairman.
Thank you, Delegate Reed.
We heard all of these issues in subcommittee, both from the Executive Secretary's office, from the Clerk's office, and from the Family Law Coalition. Randy wasn't there, but others were. We heard all of them. We watered the bill down. Even in a stronger form than this, the recommendation was a 7-1 report, having heard those concerns. The bill has now been narrowed further, and so the motion is to report.
Second, Delegate Toscano.
Thank you, Mr. Chairman. When Mr. Dix come back to the podium, because I was a little unclear what he was saying, are you saying that the clerks are okay with this bill now, or are you suggesting that we should insert some phrase that says, upon good cause shown?
Mr. Chairman, I'd say the latter. Good cause. The clerks don't express a policy position about the parents delivering the orders and so on. As Delegate Beach said, this is narrowed and watered down, to use that term, since the subcommittee meeting. At the same time, we still see the issue on lines 146 through 148 that it will become standard just to request that the court, which really means the clerk, deliver. So we think for good cause shown will be the appropriate standard.
Mr. Chairman.
Delegate Toscano.
Question for Delegate Campbell. So Delegate Campbell, I'm curious why you wouldn't be willing to accept an amendment like that, so that lines 146 through 148 would actually say, upon good cause shown, the court shall cause the custody or visitation order to be transmitted to the school, et cetera, et cetera, et cetera.
I guess I view that there's two burdens there. There's obviously a burden on the clerk's office to transmit the order to the school, and I would view that being transmission by fax or letter, which would take a couple of seconds. Upon good cause shown would invite, I would think, some sort of inquiry by the court, which I would think would be even more burdensome.
Do you oppose that?
I think I do, just simply because I view it as being less
Okay.
burden on the clerk.
Anybody else? Okay, the motion then is to, report the bill as amended. Is there a second? Second. Moved and seconded to report the bill as amended. All those in favor, indicate your vote electronic voting board. Somebody want to vote for Mr. Campbell? I will authorize somebody to vote for Mr. Campbell. Yeah. You go ahead. Okay, close the roll. Reports 19-2.
Mr. Chairman, I think you were okay with this jumping out of order since Chairman Lingenfelter's here for his second bill. So we would jump to HB 2385. This actually came out unanimously, but was put on the contested docket because there were some questions we wanted answered, and the chairman's here to present his bill.
Okay, Mr. Chairman, essentially what the bill does is right now, local, state, or local authorities can use a thing they call e-summons. So if you get stopped, and you can print out a little summons and give it to you, and it automatically notifies the Supreme Court, notifies everybody supposed to be notified. State police, under this bill, would be permitted to do the same thing. Same rules, same fee, but this would allow them to essentially use this e-summons when they're out on the road, stopping somebody on the road, and print out the summons, hand the person, and all the rest. That's what the bill does. It's the same fee as the local.
Mr. Chairman. So the question that we had was, we were just picking the same $5 up, so we had some questions about what the system would cost, how many tickets were written, and what was the ratio of the revenue to the average cost. And then ultimately, once we get that, then sort of the binary decision is, do we want the state police to have the e-summons system or not, and if we do, how do you want to pay for it?
Okay, yes, sir.
Mr. Chairman, members of the committee, Dan Wilson with the state police. The numbers that I'm going to give you will assume a full implementation of the program, which is not the case. There's only about 15 jurisdictions that have this program currently. But the state police write about 650,000 tickets a year at about $5 a pop. That's 3.25 million. And what would the system cost to implement is about 5.2 million. So it would be a money loser essentially, but the program is only going to be implemented per jurisdiction. So it's going to be over a great deal of time and slowly. And I have a further breakdown if Delegate Habib needs that.
Mr. Chairman. Delegate Lingenfelter.
If it is the will of this committee to report this bill, then I would be fine to send it up so we can do a double check to make sure that this does not have a negative impact on the budget that we are, as we speak, right now crafting. So that's what I would say to the committee.
All right, any questions? Okay, does anybody in the audience want to speak for or against the bill? Delegate Habib.
Well, I was just going to say, it sounds like the right motion then would be contrary to what the subcommittee did, which was recommendation to report. It would be to report and refer to appropriations.
Okay, the motion is to report and refer to appropriations. Is there a second? Second. Moving second, report and refer to appropriations. All those who want to vote in this bill, indicate your vote in electronic voting board. Okay. Collins. Oh, sorry. There you go. It's Jason here. Okay, close the roll. 15-6 at the reports.
Thank you, Mr. Chairman.
Bill.
Mr. Chairman, our next bill is 1941. This did have a tighter vote. It's Chairman Kilgore's bill. I'm not sure we have people here to testify. We had a substitute at the subcommittee, and then I believe there is a line amendment to substitute. I'm sorry, we have an updated substitute that's in front of you, which incorporates the most current language. I voted against the bill, so I'll then turn it over to Chairman Kilgore if that would be okay.
Okay, Delegate Kilgore.
All right, what this bill does is it's an anti-SLAPP bill. Last year, Delegate Lupasi carried a bill which started us down this road. What a SLAPP bill is a strategic lawsuit against a public participant. And what we're trying to do is, now there are lawsuits being filed against individuals who go in and type something like, this is a horrible restaurant, or Iron Maiden is not a good band or something like that. You know, it's something like that. So we had a discussion in, subcommittee, and I think the chairman of the subcommittee would agree that most of our discussion centered around whether matters of public concern, that definition. And what we did with the substitute was narrow that. And what I narrowed it to was a matter of public concern means matters of interest to the community which are written or spoken word, spoken statements related to an issue properly before a governing body, an issue reasonably likely to encourage consideration or review by a governing body, or a good product or service in the marketplace. And if you look at what the U.S. Supreme Court has noted, that speech of this nature includes political, social, or other concerns to the community. And you know, most of the folks now, if you're going on a trip, you're using Trivago or Yelp or something to find some item, you're looking at what individuals say about that, comments, and what we're seeing is, and we had evidence at the committee hearing of folks who have been sued and you know, tried to quash their statements. So basically, that's what the bill does. I think the vote was, it was reported 6-3, but I think it was actually 7-2 because I think someone voted, meant to vote yes and voted no, and that's the deal. And I would move that we adopt the substitute that's before us if it hasn't been adopted.
Okay, moving second adopt the substitute. All those in favor say aye. Aye. All opposed? Substitute's adopted. Delegate.
Yeah, I'll just explain. I mean, the vote was to report, but I'll just explain what the opposition to the bill was that I had. We have had an anti-SLAPP bill in Virginia for a very long time. It has been limited to appearance before a public body to petition on a matter of public policy. Last year, we addressed that bill and we strengthened it through the attorney's fees provisions and some other things. There was a proposal last year to apply that anti-SLAPP protection to matters outside the public forum, which would be like letters to the editor. So it's one thing to appear before the board of supervisors and say, I oppose this. It's nothing to write a letter to the editor. So we evaluated that last year and rejected that proposal and said, no, we need to limit this just in the forum. So that this bill makes two changes, again, which are just public policy questions for this body. It does what we rejected last year, which takes it out of the public body, the board of supervisors, the city council, whatever, and applies it to any public speech. So that would be websites, newspaper articles, standing on the street corner, any of that. And it also redefines public concern to not just be matters of public policy, but like restaurant reviews and the quality of the service you receive and that type of thing. I actually don't have a problem with evaluating whether or not that should be protected speech, but I don't think the protection for commercial speech should be equated with the protection of political speech that exists in the anti-SLAPP statute. So my opposition is both pulling it out of the public forum and putting it into just any public statement, and then the equation of this sort of economic commercial speech with First Amendment protected public speech. I was obviously in the minority. It did report out 7-3. The change doesn't affect either, the line amendment today doesn't fix either of those issues, so I'll still vote no, but again, I'm in the minority.
Yeah, I would say that, you know, this isn't novel. A lot of states have adopted, 28 states have adopted some form or fashion of this, and, you know, like Texas and California have adopted almost this exact, well, probably not this exact language because we just amended it, but you know, something that there is a need for protection on it, and it is, you know, we've become more of an electronic society, relying on something, certain things, and you don't want to have somebody who says this is a bad restaurant or.
Mr. Chair.
If it's not true, you still have an action. You can still file a. If you say something that's totally not true, that. You know, for example, I stayed in this hotel and it had bed bugs in it, and they can prove it didn't have bed bugs in it, then they can sue you. That doesn't. I don't think that protects you from that.
Mr. Chair, we're getting
confused. I have Jason.
Yeah, Jason's my lawyer on this.
So I'm looking at lines 18 through 20, and it says that a person is immune from civil liability for a claim of defamation based solely on the statements made by that person. So what if those statements are just completely false?
Mr. Chairman, members of the committee, already in this code provision, if you look down at the end of paragraph B, there's a provision where this immunity does not apply if it's a false statement or you're reckless in
not avail yourself of this immunity. That's the current law, and this bill doesn't change that caveat or that prohibition to avail yourselves of this immunity. This is meant to protect honest, free speech regarding matters of concern to the public, and really in two different ways. There's public policy issues and matters, and then really it's not really commercial speech, it's actually consumer speech. So this is protecting consumers writing honest reviews for that nature.
Okay, Delegate Bell. How am I getting it? So let's assume 3 statements are made. Someone goes to Delegate Alba's office to hire him, and they walk out angry, and they go on one of these services. So that would be covered. So far, so good, right?
Correct.
Okay. And the first is they say he is a mean person. He wasn't respectful of me. So that's an opinion. And he wants to sue them and stop them.
It could be a statement of fact.
Well, I'm going to get to that. And then the next would be he lost my case because he's a bad lawyer. And the third is he stole my money. Now, what does this get you? So David wants to defend himself against the defamation claim. Well, how does this rejigger the steps that someone can take?
Right. Mr. Chairman, the difference is here if it's a matter of interest for the community, and I would say that is regarding as a consumer, I think it would fall into the definition of matters of public concern. What it does is it allows certain protections for speech, for essentially heightened speech. Speech that's important for public policy purposes, or speech that's important
This
for
involves a
consumers.
service in the marketplace.
Correct. Okay. So 3 little I would presumably apply to your hypothetical. Again, opinions, you get into defamation of opinions, but if it's a statement of fact that
So what? I'm missing the so what. So this is in place. Do they then get to file what, a demur or something?
it's an affirmative defense, which is already part of the law for this very narrow scope of public speech before local public bodies. That's the current law, and all we're doing is expanding it from just speech before a local public body to also include written speech, and then speech essentially related to consumer reviews, the goods, products, and services.
Okay, I'm not understanding what, so this goes into place. What does the plaintiff get? What does the defendant lose? What's the defendant get? What's the plaintiff lose? In other words, Alba sues for defamation.
Sure. And if this immunity applies, this is essentially a gatekeeping a mechanism for a certain type of speech to try to quickly resolve this on behalf of the defendant.
How?
Who's had, well, first of all,
there's no defamation cop.
Right. First of all, you file a motion to dismiss based on this immunity. You have that hearing, presumably in fairly short order. One of the things that was removed at the request.
How? I'm not. So you have the hearing, and the big issue is whether it's true or not.
Correct.
It's the same issue.
Correct.
So
Which is still part of the current law. That hasn't changed with this bill.
So
That's currently protections.
I'm not trying to ask quick trick questions. I don't have an opinion of this. So then what happens? How does that help him? If the issue then comes back to whether it's true or not.
Right.
How does this move this at all, except having?
It gives you, like I said, it gives you an additional affirmative defense to raise immediately without having to go to trial and litigate the actual defamation case. This is kind of a gatekeeper opportunity. And again, that piece, that process piece is actually part of the law already. This is part of 801.2223.2. So
I'm still not understanding how this hearing, so you have a hearing.
Correct.
And Albo says, the guy says it's a service.
Correct.
Albo says what? Is false or reckless disregard of what's false. And then the judge has to hear the whole case because he's got to figure out if it was false or not.
Just the false part. Obviously, defamation case, you have several elements, at least 8 elements of a defamation case that you have to go through. What you're doing here is determining whether it was false, whether the immunity applies. If it is a false statement, then you don't go through all the other elements of a defamation case.
I'm missing how this shortens anything. It sounds like it's an extra hearing without, I mean, if in fact you're allowed to say false things, that's a different discussion we can have.
Correct.
If it's, I'm missing what the benefit is.
Like I said,
I mean, either this does a lot or it doesn't do a lot. I'm trying to figure it out.
Like I said, our position is because the law already allows for this type of defense, this immunity, then we're just expanding the speech to it. We're just literally expanding the type of speech that you can avail yourself of this immunity, like any other immunities that are in the code.
Okay, so Mr. Chair, Delegate Habib raised the issue I guess I would ask the patron or the speaker. You have two things you're doing. You're expanding where the public comment, if you will, political speech can apply.
Correct.
And then this sort of very big expansion of what kind of speech is covered. So it goes from you at the podium to you at the street corner as the first step, which I'm not sure is that controversial. But then there's the every service, every product, every good
In the marketplace.
Yes. Every comment about a barber, every comment about a cook, lawyer, restaurant.
Mr. Chairman, I'd be glad to explain the policy behind that, why the marketplace, why language regarding consumer speech is important in today's economy.
It's massively important. They say that entire companies rise or fall based on these, and I'm not sure why we are providing a lot. I mean, you're putting a finger on the scale on the side of the guy who is commenting, whether he's telling the truth or not.
If it's an honest review, because we rely so heavily on those reviews now in our economy. 15 years ago, no, it wouldn't be a matter of public concern what somebody says about another, a product, a good, or service. But now, over 70% of all purchases of goods and services use some type of review, online review, whether it's Yelp, which is my client, or whether it's Angie's List, or you go on Amazon for a product. So because consumers now rely not only on the free flow of free flow of goods and services, but also on information.
Okay, Kelly Khabib.
I just wanted to make 3 additional points that hadn't been made, and 2 of them in response to what Mr. Ide said, because I think I need to clarify what he said. There's a third major change here, which is the change in the basic standard defamation law. As you know, in Virginia, truth is a defense of defamation, but you don't, unintentional truth is not a defense unless it's a case requiring actual malice. So if it's a public figure, you have to show actual malice. What this is saying is that we are now exempting all unintentional untruths from defamation law. That's a massive shift in defamation law. That's point number 1. Point number 2, the testimony was, well, this is a gatekeeper role. Well, Virginia courts don't really have a gatekeeper process because we don't have Rule 12 motions. You would have to file a special plea of immunity. All special pleas, a party is entitled to an impaneled jury to make all factual determinations. All of this is subject to numerous factual determinations. So what you're actually going to do is not gatekeep these cases, you're going to try them twice, because you're going to try a special plea of immunity. If you lose that, you're going to then have your full case with another impaneled jury, another set of jury instructions, and everything else. Third, just by way of example, Maryland has an anti-SLAPP lawsuit. It's in the news today because during the campaign, a blogger in 2 news outfits called Melania Trump, a high-priced escort in her past. She has filed a defamation lawsuit for $150 million. The blogger who called her a high-priced escort filed a SLAPP defense and said, I'm immune because that's a matter of public concern. Now, the judge ended up denying that motion and said, you calling someone a hooker is not a matter of public concern. The problem is, 1, some other judge might not. 2, they now had to have the gatekeeper hearing that Mr. Ige is talking about, litigate that whole thing, do discovery, spend all that money to just get into what everybody knows is a basic defamation lawsuit. The next thing that person would have said is, well, if it's false, it's unintentional. I thought she was a hooker, and because I didn't know she wasn't a hooker, it's okay for me to say that. So again, there are legitimate policy debates to have. I understand Yelp's economic interest in doing this. I think the right way for Yelp to protect their posters, if this is a problem for them, is to offer insurance to everybody who posts there that they will defend them in a defamation case. They don't want to do that, obviously, because that shifts the cost to them instead of to the person exercising free speech. But anyways, again, we litigated this last year in the public forum versus outside the public forum, and now we're expanding even further.
Okay, Mr. Chairman. Did somebody order a page who wanted to come pick up this nice little young man and said, you did?
Yeah.
I think he was looking for you. Okay, all right. Okay, who's, anybody else? Okay, who's there? Yes, Delegate Bell. I mean, I think the less controversial part won't be of any interest to the Yelps of the world, but would be. But I'm just saying that I think we would be open, some of us would be open to the idea that you should be able to make fun of us there, here, anywhere, because we're politicians and that's kind of the deal. But if I'm a mom and pop business and people are lying about me on the internet, I don't want to put up additional hurdles to that person getting some kind of redress, given how powerful Yelp has become.
Mr. Chairman, I would like to respond. There's already federal law that protects the Yelps of the world, the platforms, the online platforms. So this doesn't protect Yelp. This does protect the consumers who are giving
honest reviews. This is not meant to protect those that are trying to trash competition, that are making up false lies about other individuals. This is not commercial speech protections. This is for consumers and those that are actually talking about public policy matters. And again, the procedural process of actually utilizing this affirmative defense is already baked into this code. Our bill doesn't change the procedural dynamic of utilizing the immunities that are provided here.
Okay, you want to speak now?
Thanks for hearing me. My name is Wendy Martin. I represent Virginians for Anti-SLAPP legislation. I was here last year. Manoli sponsored a bill seeking to get the goal of anti-SLAPP legislation here in Virginia. I do want to point out, as they've said, this is not a red state or a blue state thing. In 28 or 29 other states, they already have these. We're playing catch up. I want to share my story. We've talked about consumer speech, but I'm also just talking about First Amendment rights and First Amendment speech. This legislation is very personal to me. In the summer of July 2013, my husband and I were among a group of about 50 parents who wrote a letter to the superintendent of schools at Richmond Public Schools. We wrote a letter to the superintendent of schools outlining safety and educational problems at our daughter's public middle school. RPS school board member Kim Gray later referred to this letter as being, quote, full of verifiable facts. The school principal, seeking revenge for our criticisms, so often SLAPP suits are just revenge suits. They're just to cause somebody hell. But seeking revenge for our criticisms and an insurance payout, she sued us for defamation and malice and $3.5 million. A circuit court judge shut this lawsuit down, yet the principal appealed it to the Virginia Supreme Court. They shut it down. So she filed a petition for a rehearing, and they finally, ultimately denied that. But what were the costs to my husband and I? We had 455 days of feeling like we had a gun to our heads. Lots of sleepless nights. I gained 20 pounds from the stress of this. We had legal fees that approached almost $40,000, all for exercising our First Amendment rights, writing a letter to the superintendent of schools to advocate for better schools. I hope you all will agree that this is an outrage, and I will come back here every year. I'm not here for myself anymore. I'm here for every one of you. You're all concerned citizens. I wrote a letter to the superintendent of schools. If Virginia had had the protections that exist in 28 or 29 other states, I feel certain that we never would have been sued. And that's why I think, we've got to get anti-SLAPP legislation here. We've got to get on board.
Mr. Chairman. Mr. Chairman, if I may. That this witness and the next witness have very valid points, and they're talking about classic SLAPP protection for First Amendment protected speech regarding a matter of public policy. They want to move it outside the room and into the newspaper. Totally appropriate debate. That's the thing that Delegate Bell is pointing to, that's the less controversial part, because this is already special speech. They don't actually care, I don't believe, about protecting someone commenting about the nature of their Chinese food on Yelp, and they probably should be offended at the equation of Chinese food speech to the policy issues that they have dealt with, which is what this legislation does, which is what's been my problem all along. We need to protect First Amendment speech the way it ought to be protected, and then we ought to evaluate the right way to protect online speech. But equating them together is what is causing the problem with this bill.
Okay, yes, ma'am. Want to speak?
Just very briefly. My name is Carol Wolf, and I'm a former Richmond School Board member, and Wendy was one of my constituents when this happened. Excuse me. Oh.
Go ahead.
So, the really important thing to me is that we get third-party protection. We have a lot of parents who cannot come to a school board meeting or have concerns with the education the kid is getting. They can't always come to a public forum. They're expressing themselves, not necessarily to the superintendent, to the newspaper, but trying to get improvements in the schools. And if you criticize, she shouldn't have to, but we need the protection. We need the protection of taking it into a third party.
So here's the controversy we're dealing with. We understand what you two want, and I'm not speaking for everybody else, but I bet you everybody else agrees with me. We think that your problem should be protected, because if you have the right to say it in a school board meeting, you should have the right to write it in the newspaper. The problem is this bill is more expansive than that, and it includes people writing things on the internet saying, I wouldn't go to this tailor because he uses bad thread, you know, or bad language, and so that's what we're struggling with now. I just want to assure you that all of us are sympathetic to your problem, so, okay?
Thank you very
We
much.
need to start moving the ball, so who wants to do something? Ellie Bell.
Mr. Chair, I don't know this to be true, but it sounds to me like some of us don't like having these two combined together. It's not my bill. So I'm about to offer an amendment to strip out part of it. I'm looking over at Mr. Kilgore because it's his own rule that says if you want to do something I'm not trying to do, get your own bill. The alternative is to vote no because, and then you bring the good down with the bad. That's what I'm about to do. All right, so Mr. Chair, with that, I would move on line 15 to delete the little two little I. All right, I guess I'd ask staff how to do this. I want to strike out option number 3, starting on 15 through the end of 16.
Just strike 15 through 17.
And then you're left with all the public issue stuff, and we've added defamation to the protections, and it can be, a matter of public concern can be raised in the newspaper, on the street corner, not just at the podium at a public meeting. But it does not say that we've changed the rules for someone commenting at a restaurant.
Okay, so Delegate Bell's amendment, I guess, would be on line 14, you would strike out the little I, right? The statements relating to an issue properly before a governing body, period, and then strike the rest of the paragraph. They have that right, Brett?
Mr. Chairman, so will it now read, for purposes of this section, matters of public concern means matters of interest to the community, which are written or spoken statements relating to an issue properly before a governing body?
I'd ask the people smarter than I in civil side, like Delegate would be, whether we need number 2.
No, Mr. Chairman, this is the problem we actually ran into why we didn't do this last year, was sort of trying to define those terms. I think if you're limiting it to something before the body, before a body, you don't need to define matters of public concern. So what you're saying is, appearing before the board or outside the board, any matter that is before their purview would be covered. I understood that to be what Britt just said. Now, the problem you have is that's not why this bill's been filed this year, so you're going to lose your lobbyists. But I would agree that that's the right way to do it, and I think that's the right policy.
Okay, so Delegate Bell has made that motion. Is there a second? Second. And moved and seconded now. That's right. You want to comment?
I might as well just strike the bill then. It's not what I put the bill in for. I don't really feel good carrying it.
Mr. Chairman, I would withdraw my second if the amendment is made at the objection of the patron, and then we would just be left voting up or down on the bill right now.
Okay, well, we do this. So you want to carry it by for the day?
Yeah, let me carry it by.
Okay, motion is carried by for the day. Is there a second? Moved and second to carry by. All those in favor say aye. Aye. All opposed? Okay.
All right, Mr. Chairman, the next
Carried by.
on our list, we already took Delegate Levine's aye for the day. That takes us to Delegate Leftwich's bill. Mr. Chairman, Delegate Leftwich's bill was uncontested but needed a line amendment, that's why it's here. It's 2281. This regards what happens with residential rental property at the time of a foreclosure. I think it has all been worked out by all of the interested parties, Poverty Law Center, Mr. Dix's clients, and others. Mr. Leftwich said we had a line amendment, so I would first move the substitute, at which time I'll then move the line amendment.
Motion to remove the substitute. Is there a second? Moved and second to adopt the substitute. All those in favor say aye. Aye. All opposed?
Now I'll move the line amendment.
Line amendment, report please.
Page 2 of the substitute, Mr. Chairman, line 38, after receipt, strike, if due to the termination of the rental agreement, the tenant will be residing in the dwelling unit for a partial month, the rent that month shall be prorated.
I would move that amendment.
Okay, is there a second? Moved and second. All those in favor of adopting the amendment say aye. Aye. All opposed? Okay, the amendment's adopted. It came out uncontested except we needed that. Delegate Leftwich, why don't you just tell us what your bill does?
Mr. Chairman, what this bill does is clarifies that if a rental property is foreclosed upon, it sets forth the procedures for how you deal with the tenant. It moves the tenant's lease to a month-to-month rent. It prorates the rent for the person. It also, under current law, any security deposits would be returned by the foreclosure purchaser, not by the foreclosed party. Again, it's worked out by the folks who rent property as well as by the folks who represent the tenants. The line amendment today was largely non-substantive to do what we thought we'd already did, so it should still be unanimous out of civil sub.
Anybody in the audience want to speak against the bill? Okay, Delegate Habib moves the bill, substitute and amendments to report. Is there a second? Second. All those in favor of this signify by getting your electronic voting board. Okay. Delegate Kelly, want me to vote yes?
Bill votes aye.
Okay, close the roll. Good reports. Okay, we're gonna work just maybe 5 or 10 minutes because I think that'll help you guys.
And we just have one more bill.
Okay, well, let's just do yours and then we'll adjourn.
All right. House Bill 2324 from Delegate Yo simply adds to the methods that jurors can be paid. Payment through a prepayment debit card or card account includes language that those cards must come with at least one free withdrawal. The motion was 9-1 to report the bill as introduced, and I so move.
Okay. All right, there's no amendments, correct?
No.
Okay, so moved and seconded to report. All those who want to vote on this indicate you vote electronic voting board. All right, close the roll. Reports 19-0. As I understand it, we have one more we have to.
Mr. Chairman, I just say that finishes our report. Civil sub does have to meet again. I think we have to meet next Wednesday because you're referring us a bill out of criminal, and we have 2 other bills. So next Wednesday we'll have our last meeting.
Delegate Bell, you had a matter you needed to.
Mr. Chair, 2127, the only reason it was not sent up already was there was a line amendment that we all agreed to that we apparently did not properly make part of the bill. So we reported without including the amendment. Okay, so, no, we reported, we just need to make the amendment here. Staff about this, we just need to make the amendment we all agreed to make this up. So I'd ask staff to report the amendment.
Mr. Chairman, the amendment is to the substitute on line 162, strike, well, it's 162 through 165, strike from shall on line 162 through the division on line 165, and insert in the absence of the receipt of a written objection from the victim in the most recent 10-year period.
Mr. Chair, would so move.
Okay, so well, first of all, remind everybody what the bill does. Why don't you explain?
This was allowing for additional retention of perks, which are the evidence recovery kits that are made after sexual assault, to allow them to stay for longer if there was an objection by the victim who had authorized it in the first place. It has to go upstairs because there's a cost.
Okay, and then what's the essential thing, the element the amendments do?
Well, we said that we have only 10 years, but what if there's 10 years and then 10 years more, so we had to include not in the most recent 10-year period rather than just saying 10 years.
Okay. All those in favor of the amendment say aye.
Aye.
All opposed?
Mr. Chair, we unanimously recommended that it be reported and referred up to appropriations, and I so move.
Okay, the motion then is to report and refer, 2127. Okay. All right. Okay, close the roll. It reports 18-0. Okay. Okay, you can put Watts as a yes. Okay. That reports. Okay, now, as a matter of business, just to give you guys an idea on scheduling. Friday is the last day we can act. We will have probably a long day of session, which means I doubt we get here until probably 3. And you're going to want to tell your families this weekend that you might be leaving late on Friday. Okay, so I think last time we didn't leave till 7 p.m. last year. Wasn't that bad? Okay. So, yeah, just heads up, so you guys can win some points at home. we adjourn. And then mental health is starting as soon as they can rally. And then ethics is in 4 West upstairs. 4 West? Yep. We're adjourned.
I've come to take this one. That's your last recording session? Are you done recording now?
Yeah.
Oh, you have another one?